Hello viewers, welcome. The lesson of today is on John Rawls' theory of justice. Some of the earliest thinking about justice is found in Aristotle. It was he who distinguished between corrective justice and distributive justice. The law of torts is often justified in terms of corrective justice. Seen in this way, its objective is to do justice between the parties without taking account of larger distributive issues in society as a whole. Most contemporary writing about justice is about distributive justice, about the appropriate distribution of goods. In the Nicomachean Ethics, Aristotle puts forward the view that goods should be distributed to individuals on the basis of their relative claims. Such an idea is but a framework for examining different conceptions of justice. Thus, goods might be distributed according to needs or desert or moral virtue, etc. The relationship between law and justice has been a major question in legal theory over the years. The substance of justice is as much, if not more, a question of political philosophy as of jurisprudence. It is ultimately a question of perceptions of the relations of human beings in society. It would be quite false to claim that there is any singular or uniform concept of justice to be found in classical and modern theories. There is, however, an identifiable concern with human relations in a social order and the need to balance their particular needs and wishes with the claims of the collective order in which they live. That is to say that justice in one way or another is concerned with issues of distribution. In modern discourse, this is a concept which has tended to be treated largely as a matter of distribution of wealth and material goods. Thus, questions of distribution arise, and with them the questions of both of distributive justice and of whether or not distribution is itself a relevant criterion of justice in social and political analysis also arise. In modern writings, contrasting views of this question have been set out by John Rawls and Robert Nozick. John Rawls, holder of the chair in philosophy at Harvard, produced in 1971 a theory of justice, which called for a new look at the principles of social justice. Robert Nozick, who had studied under Rawls and who also held a chair in philosophy at Harvard, produced in 1974 Anarchy, State and Utopia, a plea for social libertarianism based upon an entirely different approach to that taken by Rawls. Both the works aroused considerable interest, both exemplify important facets of the continuing concerns of contemporary American jurisprudence. In this lesson, it is proposed to provide a sketch of the most important general aspects of Rawls' theory of justice. For a few years after its publication in 1971, John Rawls' book, A Theory of Justice, was almost entirely ignored by both teachers of jurisprudence and writers on jurisprudence. They thought that it belonged to political rather than legal theory. All this has now changed. Rawls' theory of justice as fairness is now an integral part of almost all courses in jurisprudence. As one commentator observed, one cannot think about justice without taking a position on Rawls' theory of justice. The rejection of utilitarianism. Rawls regards utilitarianism as an unsatisfactory means by which to measure justice. His attack on the principle of utility is, however, different from other anti-utilitarians. Rawls' hostility towards utilitarianism is based largely on two features of the theory. First, that it fails to recognize the separateness or distinctness of individual persons. Secondly, Rawls argues that questions of justice are prior to questions of happiness. In other words, it is only when we regard a particular pleasure as just that we can say whether it has any value. Utilitarianism defines what is right in terms of what is good, whereas Rawls regards what is right as prior to what is good. Social contractarianism. Rawls' starting point is an idea of justice as fairness. From this, he developed a detailed analysis of principles of justice. His argument is set out in a generally social contractarian form. Rawls' theory of justice as fairness is rooted in the idea of social contract. His aim is to present a conception of justice which generalizes and carries to a higher level of abstraction the familiar theory of social contract as found in Locke, Rousseau, and Kant. In order to do this, we are not to think of the original contract as one to enter a particular society or to set up a particular form of government. Rather, the guiding idea is that the principles of justice for the basic structure of society are the subject of the original agreement. They are the principles that free and rational persons concerned to further their own interests would accept in an initial position of equality as defining the fundamental terms of their association. These principles are to regulate all further agreements. They specify the kinds of social cooperation that can be entered into and the forms of government that can be established. This way of regarding the principles of justice he calls justice as fairness. This passage captures the essence of Rawls' theory of justice. Rawls argues that we must distinguish between people's genuine judgments about justice and their subjective self-interested views. In doing so, it is plain that the position adopted by a hypothetical neutral outsider concerning what is just is likely to be fairer than that which we hold as parties who have a vested interest in the outcome. Once we have arrived at those objective principles, we should measure them against our own judgments. The inevitable distinction between the two must be corrected by our modifying our own judgments in such a way that we eventually reach a situation in which the two are similar. This is the position of reflective equilibrium. The people in the original position in a wheel of ignorance. In order to discover principles which may be considered objectively fair, that is not a rationalization of particular wants, Rawls employs the device of the people in original position placed behind a wheel of ignorance. Rawls gives us an imaginary picture of the people in original position, each shrouded in a wheel of ignorance, debating the principles of justice. This ignorance prevents them from knowing to which sex, class, religion, or social position they belong. Each person represents a social class, but they do not know whether they are clever or stupid, strong or weak. Nor do they know in which country or in what period they are living. They, however, possess only certain elementary knowledge of the general facts about human society, for example, political affairs, economics, and psychology. In this state of blissful ignorance, they must unanimously decide upon the general principles that will define the terms under which they will live as a society. And in doing so, they are moved by rational self-interest. Each seeks those principles which will give him or her the best chance of attaining his or her chosen conception of the good life. So, stripped of their individuality, the people in original position will opt for a maximin principle, says Rawls. It will be noticed at once that there are two broad types of knowledge of which the people in original position are deprived behind their veil of ignorance. These are, first, knowledge of personal characteristics, and secondly, of the conditions of the society for which a standard of justice is to be devised. Rawls presents a list of the specific deprivations of knowledge imposed by the veil of ignorance. They are place in society, class or social status, natural assets or abilities such as intelligence and strength, personal conception of good, personal life plan, psychological inclination, the economic and political situation of their society, the level of civilization and culture attained by their society, and the generation to which they belong. So, according to Rawls, the people in original position involved in the selection of principles will hold their discussions behind a veil of ignorance, so as to achieve objectivity. They do not know how the choice of various alternatives will affect their own particular lives. Hence, they are obliged to evaluate principles solely on the basis of general considerations. The basic theme in Rawls' theory is that the choice of just principles for social organization is to be made by persons who do not know what actual position they are to occupy in the society, nor what their particular interests and inclinations will be. They are thus precluded from shaping their principles by reference to personal advantage and can only proceed upon the basis of securing to the greatest possible degree fairness for all, including themselves. It is important to note that the people in original position in a veil of ignorance may be accepted as a rhetorical device used for the presentation of arguments leading to the two principles of justice. The two principles of justice. One of the most interesting modern attempts to defend principles of justice is Rawls' A Theory of Justice, as now reformulated in political liberalism. Rawls enunciates two fundamental principles of justice. According to him, these two vital principles will emerge from the discussions of the people in original position. The first principle: each person is to have an equal right to the most extensive total system of equal basic liberties compatible with a similar system of liberty for all. The second principle: social and economic equalities are to be arranged so that they are both to the greatest benefit of the least advantaged, consistent with the just savings principle, and attached to offices and positions open to all under conditions of fair equality of opportunity. The conception of justice for which Rawls argues demands the maximization of liberty subject only to such constraints as are essential for the protection of liberty itself. Equality for all, both in the basic liberties of social life and also in distribution of all other forms of social goods, subject only to the exception that inequalities may be permitted if they produce the greatest possible benefit for those least well off in a given scheme of inequality, and fair equality of opportunity and the elimination of all inequalities of opportunity based on birth and wealth. The priority rules. Rawls suggests further the people in original position will enunciate priority rules in order to resolve possible conflicts where the principles of justice might run against each other. The first priority rule, the priority of liberty. The principles of justice should be ranked in lexical order. As a result, liberty can be restricted only for the sake of liberty. There are two cases. A less extensive liberty must strengthen the total system of liberty shared by all. A less than equal liberty must be acceptable to those with the lesser liberty. The second priority rule, the priority of justice over efficiency and welfare. This principle is lexically prior to the principle of efficiency and to that of maximizing the sum of advantages. Fair opportunity is to be considered prior to the difference principle, that is, the principle that people ought to be treated differently only where this will be advantageous to those treated in this manner. There are two cases. An equality of opportunity must enhance the opportunities of those with the lesser opportunity. An excessive rate of saving must on balance mitigate the burden of those bearing the hardship. Supremacy of the basic liberties. In Rawls' scheme, basic liberties are supreme. Justice is fairness, but fundamentally, liberty is all important. Liberty may be interpreted as a certain pattern of social norms. Basic liberties include political liberty, freedom of speech and assembly, liberty of conscience, freedom of thought, freedom from arbitrary arrest and seizure as defined by the concept of the rule of law. The rules and laws defining basic liberties apply to all persons equally. They may not be circumscribed save where equal rights as institutionally defined would interfere with one another. It should also be noted that a departure from the institutions of equal liberty required by the first principle cannot be justified or compensated for by greater social and economic advantages. Distribution of primary goods. The rational distribution of social primary goods will be an important matter for discussion and decision. These goods are the things every rational person is presumed to want in relation to his life plan. These are rights, liberties, opportunities, and powers. At a later stage, Rawls suggested that the most important good was self-respect. For every person, the good is the satisfaction of his rational desires. Primary goods are the necessary means to that end. Rawls suggests that the decision of the people in original position would be that all social primary goods should be distributed equally unless an unequal distribution of any or all of them is to the advantage of the least favored members of society. Rawls admits that in addition to these social goods, there are natural goods such as health and vigor, intelligence and imagination. These are, however, much less at the disposal of society in terms of their distribution, even if they may be affected by social conditions. Thin theory of good and full theory of good. The starting point for the working out of principles for just distribution is set out in a thin theory of good, which Rawls states is limited to essentials and the function of which is in effect to establish the premises about what a just system is to distribute. Once objective principles of justice have been worked out, they can, of course, be related to a much more detailed sense of goodness in society, which Rawls terms a full theory of good. Thus, the principles of justice rest upon the assumptions underlying the thin theory of good, but then feed into a full theory of good. Application of the principles of justice. Principles of justice are in themselves of great theoretical interest, but are of little more concern without some indication of the ways in which they are to be applied. Rawls set out a 4-stage sequence for the attainment of a just society. Rawls admits that these stages are to some extent modeled on the processes of constitutional development in his own country, the United States of America. The 4 stages in sequence are: first, the enunciation of the principles of justice from the original position. Second, a partial lifting of the veil of ignorance so far as the general circumstances of the society, but not individual circumstances of the people. The devising of a constitutional system dealing with powers of government and the rights of citizens. This process must, amongst other factors, cope with different and possibly opposed political viewpoints. Granted the priority of liberty, the outcome is assumed to be some form of constitutional democracy. Thirdly, having established a constitution, the next step is legislation in accordance with the principles of justice as well as the constitutional procedures. The legislators are intended to act in the light of general interest rather than to their personal advantage. It is admitted that judging whether or not a law is just may be difficult, especially in the context of inequalities of the different principles, and that it may be easier simply to determine whether a law is not unjust. This proposition, of course, raises the question of the interface between the concepts of justice and injustice. The final stage is that of application of the laws and rules by judges and administrators and their working in the actions of people generally, at which point, of course, the veil of ignorance is wholly removed. Criticism. Rawls' theory of justice had and continues to have an enormous impact, but it has been subjected to a number of criticisms. The device of the original position attracted much criticism. Perhaps the most basic criticism asks why people who are not in the original position should accept principles chosen by those who were. Rawls' answer is that the conditions and constraints embodied in the original position constitute a model of procedural fairness and so should be acceptable to everyone. But what if there is a bias in the original position so that principles are not chosen fairly? To Marxists and some feminists, such bias is inevitable. The original position is so highly artificial that it is very difficult to accept it as the basis of a credible hypothesis. It is almost impossible to imagine persons in the state of ignorance presumed by the veil. If persons know virtually nothing of background, experiences, etc., how can they arrive at meaningful conclusions about their world and social arrangements within it? Further, what is the guarantee that the people in original position will choose the social primary goods as enumerated by Rawls? Dworkin, in his Taking Rights Seriously, notes that the very structure of the original position produces false arguments in favor of the participants' views. Because a person might have consented to certain principles if asked when he was behind the wheel. Is it fair to attribute continued adherence to those principles after the wheel has been removed and he has become aware of advantages and disadvantages pertaining to his social position and other interests? A number of questions may also be asked about the principles of justice. To what do the principles of justice apply? Rawls' answer is clear. He sees justice as a virtue, indeed the first virtue of social institutions. His theory of justice is a normative blueprint for institutions. The same principles do not apply to individuals. As Professor Letsas explains, people can be cruel, insensitive, mean, generous, or caring, but only the basic structure of society can be just or unjust. Is it not an unnecessarily limited conception of justice? Liam Murphy has argued that the view of Rawls is indeed unduly limited. He maintains that all fundamental normative principles that apply to the design of institutions apply also to the conduct of people. The refusal to extend principles of justice to personal conduct is prima facie deficient. There has been a live debate on the difference principle, the principle of common interests, the compatibility of two principles of justice, rationale of giving priority to liberty, etc. Despite the criticism, Rawls supports the idea of public reason and shows how the law of peoples can be developed from a generalization of liberal ideas of justice and how it extends to non-liberal as well as liberal societies. In this lesson, a moderate attempt has been made to cover the fundamental aspects of Rawls' theory of justice. Thank you.